Welcome to Your Texas Land, a place where we take a deep dive into all things related to land in Texas. I'm your host, Cassie Gresham, and I'm happy to have you join us today. In each episode, we explore topics that might affect you as a landowner, and today I'm joined by Nathan Yates, an attorney with Braun Gresham. And we're going to be talking about renewable energy in his practice. Thank you for joining us.
Thank you. Thank you for having me.
Tell us a little bit about your background, Nathan. What have you done in your legal career? You look young, but I know that you have almost 20 years of experience.
Right.
So
appreciate the compliment. But yeah, I started out my career more on the real estate side and then quickly transitioned into oil and gas with private law firms. Then went out in the field with one of our clients doing land work, title curative work. And that brought me into the space of looking at wind and solar and that sort of hemisphere of the energy sector. Mm-hmm. So that was about 8.5, 9 years ago. I joined a wind development company at the time and started developing wind projects, utility scale wind farms across the United States. I then evolved into solar as that really ramped up. And so wind, solar, then battery storage. So for the past 8 years, well, over 8 years, I did that for these energy companies internally. More recently, I'm really excited to get on the landowner side of the table. These are such large scaled projects, and there's so much that goes into them. I always felt like the landowners were at a little bit of a disadvantage understanding what these projects really are and what they are not. It's different than oil and gas. It's different than really anything that you can compare it to. So I'm very excited to be doing that now. We'll see what the next chapter holds.
yeah, I'm excited to have you. And just for our listeners, Nathan joined us in June, kind of late June, early July. And I think it's really rare to have an attorney who's been on the industry side, and the people that I know that are practicing in this world, really unique to have that industry perspective and then bring that expertise to landowner side. So I'm excited about the potential for what we're going to do at Braun Gresham representing landowners. And I think it really brings a different perspective and different skill set to the table. And you as a landowner yourself and being from East Texas, like it gives you an opportunity to give back to landowners and really utilize all the things that you learned on the industry side. So
yeah, I could not agree more, and really looking forward to getting going with it. Land is it's a very important asset. It's both practical in nature, it's emotional, it's all of the things. In Texas, we have a large amount of private land ownership. And so with these types of projects we'll be discussing, a lot of land is involved. And so it's very important to understand all nuances of where a development company is coming from, what this asset is that they plan to develop, and whether that is the right decision for the landowner. And if so, let's make sure that the partnership starts off on the right track.
Yeah, because these are long-term partnerships.
They are.
Yeah.
They very much are multi-decade and sometimes generational type partnerships.
Well, let's get right to it, and we're going to talk a little bit about what you do for landowners and what's the landscape on the renewable practice right now. So what are some of the most significant federal policies or regulations that are shaping renewable energy right now?
The Big Beautiful Bill, which passed this year, it really accelerates the end of the two major federal incentives for these projects. They've been in place for a while now. And so that the investment tax credit, the production tax credit, there's now an accelerated timeline to phase those out. So July 4th of next year, 2026, development companies need to have started construction, or by December 31st of 2027, the project needs to be placed in service. So that's your new test. That's in order to qualify. The construction aspect of it, historically, companies, obviously, you can practically start construction and break ground in a traditional sense. Or it's very common in the industry to safe harbor equipment, and that qualifies for starting construction. On August the 15th, the IRS clarified that you really need to have a significant nature test to that procurement, to that safe harbor procurement schedule of obtaining equipment. It was a 5% test. That's now more of a significant nature test. What that means practically is that a lot more procurement needs to occur to qualify.
And what do you mean by procurement?
Procurement means entering into binding long-term contracts for your major equipment. That equipment is typically transformers and nacelles potentially for a wind turbine. But essentially it's major components and a very large percentage of the overall facility components for either solar or wind project facility.
And so what do you think that these changes in the bills really mean for landowners? Does that mean that projects are going to move really fast and get accelerated, or there's going to be less projects? Kind of what does the landscape look like for landowners?
I'm going to go with both.
Okay.
So,
both and.
Right. From a practical standpoint, yes, your projects that are capable of being accelerated and that are financeable and are good projects, they will advance, and now at a slightly more accelerated rate. So they're either going to actually begin construction by July 4th of next year, or they are going to have equipment that is under contract for them, major equipment. Those are your solar panels and your transformers and your nacelles and wind turbines and everything. So from a landowner's perspective, it's more important than ever to understand if you're being approached, or even if you've already signed on to a project, what's the plan? That's what I do when I get with my counterparty now, the development company. I just talk to them on a very real level. What's going on with this project? What's the plan? How many landowners are involved? It's important to understand, is this a multi-landowner type project, or is this a single landowner type project? What is the interconnection plan and status for interconnection? That's often a long lead time type of item. Also the procurement for it. One big question I'll ask now is what's being planned for this project? Is it going to qualify for federal incentives, or are you planning for this project to pencil out not having qualified for these incentives? So it's just more and more questions to ask up front. It's really understanding who you are dealing with, and is this company going to be a long-term partner, a long-term owner-operator, or is this more of a dev and flip type company? Develop and then sell the project, flip it to an actual owner-operator. Your negotiation for a lease is different a little bit if you're dealing with a counterparty who's not going to be around in a few years. Right. So you need to think about that. It's not necessarily a deal breaker. You just need to know.
Yeah.
And you need to be sure that contract is one, and I've seen hundreds of them, that agreement, that lease agreement in place. Are all provisions in that agreement necessary, and why? Let's talk about it. Because really all the parties that are negotiating that contract now may not be around when all of those contractual obligations need to be met.
And I'm sure that they have different companies have different perspectives, different ways they treat landowners, different experience, and having your experience dealing on the industry side, being able to tell a landowner, I've seen good things from this company this company's new kid on the block, and we don't know what that looks like. I would imagine that you're bringing that to the table too.
Absolutely. Speaking from with the federal policies that are being put in place now, have been put in place, and that will be put in place perhaps, it's important that you sign up with a company who really is solid, who has experience, who has the financial capability to I'll use the term weather a storm or realign with the current reality. And if you want a project to be successful, and if you want it to go into construction, your partner needs to be one that is hyper aware of the current climate. And we need to have a conversation of how are we going to make this thing a reality? What's the plan? Because not all companies who are leasing land are actually going to be taking these to the finish line. And the reality is that less projects will be built than are currently on paper somewhere. It's currently called braggawatts. A lot of companies just have these braggawatts on paper. They're just leases. They're site control for projects that will never be built.
Yeah. What do you estimate are the projects that are actually built?
Percentage-wise, really more in the 20 to 30% range. And that's known. That's not talked about.
Yeah.
Right?
Yeah.
But I want my landowners to know.
Sure.
There's, you have a less than 50% chance of this project actually being built.
Yeah.
We want to partner. We want to make sure that that development company is on the northern end of that range, and not any less than that. Right.
Well, yeah, and it's kind of a perfect storm. I mean, there are federal incentives for these projects that companies are relying on, maybe to pencil the deal out. But then within Texas, there is a whole landscape that's happening there, because more and more, as Texas is growing, we hear from our own state government, okay, we need more energy. Our grid is not fully developed. We need more of these renewable projects in the form of wind and solar. And then we're building transmission lines to transmit that across the state.
Right.
So is there a juxtaposition of, is it different what's happening on the federal level versus what's happening in Texas? And will Texas landowners be shielded somewhat from what's happening nationally because there is a need on a state or local level to build out or to be able to transmit that energy?
Projects are absolutely very locationally specific as to how you analyze them and how a development company is analyzing them. So it's at the state level, yes, we absolutely need energy. We need it in any form we can get it. We need electrons. The crypto mining and data center space, it's increasing. It's really the wild, wild west with them right now. They need those projects in the ground. They require a massive amount of energy, of electrons. So these wind and solar farms, they are power plants. Let's be very clear with what they are. We have terminology in the industry calling them farms, right? Yeah. That's strategic.
Yeah.
Obviously, they are power plants, and they create electrons to put them onto the grid to power our state, our overall electrical grid. So Texas is unique in, we are an energy state. We have been for 100 years. And just when you think, that we have enough, we now know what our pie is. This percentage is going to be powered by this type of energy source, and this percentage, all of a sudden we are now in a position where the pie just expanded, and we don't know how large it's going to need to be. We need all forms of energy. So we're in a good position for landowners who want these projects and have been approached to advance these projects and get them built, because of simple supply and demand. It takes a long time to get a natural gas plant up and running. The supply chain, there are supply chain issues with that. And, we're in the 2030s before we get those up and running. And nuclear is even longer. So there's room in the pie, room in the sandbox for all forms of energy.
Sure.
There really are. The federal, nuances of those implications of what's going on at the federal level, it absolutely affects projects in every state. So one thing that I've found out I keep in contact with a lot of colleagues that are currently still in-house with energy companies. One thing that's going on right now that's really not making headlines, and it's pretty interesting, the permitting process with federal agencies, it's really being delayed in a manner that they have not seen before. It's playing out in real time right now. Your FAA permits for a wind farm and your U.S. Army Corps of Engineer permitting when you're crossing a stream and creating a federal nexus, those agencies are now kind of bottlenecked, and they're almost just not responding to the development companies for their permits, their applications, and status updates. And so those headwinds are concerning to everyone involved, everyone who wants these projects to move forward. And we're not sure where that's going to land. I'm keeping a pulse on it through my industry contacts and what's going on. The Department of the Interior released a memo mid-July requiring an additional layer of oversight. There's definitely a connection there going on. That oversight needs to occur whenever there's a federal nexus. That Federal nexus has a very broad definition, if it's even defined at all, really, arguably. But
Sure.
Most projects will probably have some sort of federal nexus. They need some permit that can be tied at the federal level. So there's this bottleneck occurring there as well. And it's playing out right now. And this is very new.
Sure.
And it's playing out right now in real time. It's interesting. From our perspective, I'm sure development companies may use a different term than interesting. But in any manner, it is reality. And the companies that are solid, that can, I use the term weather the storm, whatever phrase you want to use, the companies that are very legitimate and solid and well-financed and well-backed, they are going to be able to ride this out, to understand how the rules apply. And they now have the new rule book. So in that sense, there's less anxiety going on than there was 6 months ago, say. The rule book has been set and they're moving forward. But that one little nuance about the permitting at the federal level and not really knowing what those delays mean, that significantly affects landowners in the sense that those option periods that you sign up for, is that sufficient? With those who have already signed up, even with a 3, 4, 5-year option, maybe coming up towards the end of those, now all of a sudden the company wants to accelerate this project in order to qualify for the federal tax credits. These new delays in permitting are jeopardizing that whole process. So we'll see.
Yeah,
but it's
almost
important to
like
monitor
they
it.
Set a deadline and then change the permitting process.
Right.
And they were not sure what
Right.
that's going to do to
That's
the
correct.
industry. So it's interesting. Well, I mean, we want to be, the great thing about Landowners coming to you is that you are able to tell them and educate them and say, okay, this is what I'm hearing. This is what we can expect. That's a great question. Let me go ask,
Right.
my resources as we're all trying to figure that out. So,
Right. Yeah. Information's power. Being informed in whatever stage of a negotiation process or a planning process. Dealing with reality, whatever reality is. Let's get to the bottom of it.
Sure.
And then we can all proceed in the most advantageous way.
Yeah. Well, tell us some examples of how local governments are approaching renewable projects. We're going to talk to the federal and state.
So at the local level, I've often said, and I've seen this play out this way, your local governments have a large degree of power over what happens in their county. The commissioner's court can meet and come up with their own rules and regulations for their jurisdiction, right? And that's an often underutilized tool, in my opinion, at the local level. So I would encourage landowners and anyone involved in these to get with their county commissioners, get with their county judge, and just local officials in general, and have a conversation, start a conversation. Those rules and regulations can come in the forms of ordinances that establish, for example, setbacks from property lines, setbacks from infrastructure, whether that's a wind turbine or whether it's solar panels or batteries or whatever. And you can establish what is reasonable and ideal for your community. You can establish that at the local level. Don't wait on state legislatures to establish that for you. Especially don't wait on federal regulators to establish something that's going on right there in your community. But it can be hyper local. And I think that could be a good thing. I've seen it play out in a very negative way towards development companies, of course, whenever the local officials and community decide they want to restrict development. Very, very burdensome way that can kill projects. That can and has been done as well, very, very purposely. But even good restrictions, I'll call them good restrictions. Development company might disagree a little bit, but you can establish reasonable setbacks from things, right? You can establish where your transportation routes are going to occur, predetermine those. These are often in very, very rural communities. Is the road base sufficient to handle these large delivery items and equipment? Are the little bridges associated with it, do those have the load capacity to handle this? So let's talk about this not at start of construction. Let's talk about that ahead of time. Let's do some planning. And who's going to pay for it?
Yeah.
Right. So, there's a lot that can be done at the local level, a lot that has been done that I've seen all across the United States, not just in the state of Texas. I worked on projects in many states. There's a common trend in that you can get hyper local with putting some parameters around these projects and partnering at the local level to make sure that everyone's on the same page with what is and is not going to happen. So that these projects, if everyone decides they want these projects to move forward, they move forward in a manner that's most advantageous for everyone involved. It still gets built, it's profitable, it's an up and operating power plant, but it has XYZ site rules and regulations around it so it's a win-win scenario.
Sure. It's really hard in Texas because we are a property rights state.
Right.
So we do get landowners that call us and they're upset about, maybe a solar farm going in next to them or a wind farm or a data center. And it's, to your point, where they can affect that change, or if they want to have that conversation, it is at that local level with their neighbor. And we've seen some detrimental effects where we've had landowners whose property has been flooded by solar panels, not having setbacks and not having, the stormwater planned the way it needs to be. So having some conversations and working that out early on is very helpful.
And the development companies, the good ones, to their credit, they get a good stormwater permit plan in place. They understand water runoff, They understand your hydrology reports. They've done the proper planning. And so, I would say perhaps requiring that be done is not overly burdensome to a development company, right? And that's something that can be done at the local level. Because if they are not done properly, these are massive projects using up massive amounts of acreage, and they have to be engineered properly.
Sure. And making sure that one of the role that an attorney does for a landowner is making sure that if something goes wrong in that project, that the landowner is not liable for the engineering that was done on their property.
That's
making sure that the company is carrying that. And I've seen some contracts that it's a little unsure. The company says, no, we're liable. We're the ones that did the engineering. But their contract says that the landowner is in charge of all the stormwater that's on the property, which those two things don't mix.
That absolutely does not. So again, on the front end, there's talk is cheap. Let's get that contract right. Let's make sure it's clear whose project this is and who's responsible for this project. And it's just important to do. The development companies, they're run by very good people, obviously, but those contracts are drafted in their favor.
Sure.
Very purposely. And, if you really read through it and understand what's going on, some of it's necessary. Some of it requires some revision. And let's dive in deep to those.
And a little self-serving, honestly, but it's important to have an attorney review those. And,
Correct.
And so give us some examples of what you've seen in those contracts, or if you have any stories of if there was a landowner that didn't seek out help, what happened, with their contract.
One thing comes to mind in that, often in those contracts, you have blanket easements that can apply to adjacent property that you own that you may not necessarily be being paid for with a lease rate or something like that. There are blanket easement provisions put in there that allow the development company to grab a little bit of that acreage if they need it here or there. One thing I make sure I sit down with both the development company and my client, of course, is establishing what acreage are we really talking about here. Let's get detailed with this. And I understand that at that stage, there are no detailed engineering designs for the project. We all wish there were. And they're not. They're too expensive. They have to have site control to even start a process. So it's important to understand, is a provision like that necessary or not? Let's get detailed with it. Another one would be an example, a wind farm, and you have certain rates that you are offered to actually host turbines on your property. If you actually do not have a turbine on your property, it's if you have a smaller parcel within a larger wind farm area of interest, I run through worst case scenarios with my clients, pick the lease apart, say, okay, in this scenario, your neighbor has a turbine next to you, you have an overhead line running across the middle of your property, and you are being paid X are you okay with this scenario? Because you're contractually agreeing for that scenario to occur. And oftentimes, like, oh, I didn't think about that. I didn't think that would be my compensation point for having that infrastructure on my property.
Yeah.
So
because the different infrastructure carries different levels of compensation.
That's correct.
And basically, the more rights you're giving up or more burden to the land or the landowner,
Right.
higher compensation for that.
That's correct.
That use.
Right. And it's shocking to some landowners to see how small the compensation really is if at different scenario points of infrastructure on their property. I mean, that's reality. And in order for the project to pencil and really finance, I understand that portion of it too. I know why they're asking things. However, maybe we need to have a conversation about that and level that up just a little bit.
Yeah.
Every project's different, very different. It has to be looked at independently. There are no blanket lease forms and provisions that appropriately apply to every project area. Unfortunately, fortunately, we have to negotiate agreements that are very specific to my client's property and that particular project area. There is no magical Producers 88 form like we have in oil and gas.
Yeah.
That
or in real
really
estate.
applies. And
Yeah.
even Producers 88 form that needs a big addendum as well. And we can talk about that in another podcast.
Yeah.
But these are very nuanced to the exact land that we're talking about in the project. It's important to dive into the details as much as you can
Yeah.
at the onset. So
what advice would you give a landowner? They get an offer letter, a letter from a company that's saying, hey, we want to talk to you. What should they do?
they should call me.
Yeah. Obviously.
They should, but in all honesty, they should seek out counsel somewhere to fully understand what they have been presented. So going again to my point of first, who is this company? Is it a land agent who's a third party just seeking out to get land rights and try and sell it and flip it somewhere? Is it a land agent who's actually working for a company? Is that company a develop and flip type of a company? I need to have a certain, if I'm representing a client, I'm going to have a certain type of conversation with that company as to where are you going to be marketing this project? Who are you going to flip this to? And then if it's an owner operator who's approached them, then we know that. Do I know them? Do I know their track record? So the second, the landowner really needs to understand that they are not on an island having to evaluate this themselves. We're here to help. We're here to really dive into the details. These agreements are complex. They're long. Every provision in there means something. There's a reason they're as long as they are, even though we all seem to think they shouldn't be that long. When you start reading through them, there's a reason that all of that stuff is in there. So just know that you are not alone in this decision. And
it can be really scary when you get scary and exciting, or just you don't know what to do with it. And so I would imagine if I got that letter in the mail, I just would think like, well, what is this? What should I do next?
Right. Being able to evaluate what that opportunity is or isn't is important. So, again, to the point of how many other landowners are involved in this project, and really what's the end goal? What's that timeline? How does that timeline match up with your values and your dreams for your piece of land, for your property? They're very, very long in relation to normal real estate transactions. The option periods are very long. Due to recent legislation, they're not getting any shorter either, for the record. So, because these companies just want options. They just don't know what 2030 is really going to mean to them. So they're asking for a little bit longer option period sometimes. But, to that point, you just need to understand what that opportunity means for you, and does that align with what you want to happen with your land, with what's going on over the next, especially the option period, 5-7 years, but what's going on over the next decade, 20, 30, 40 years, your succession plan, the parties involved today may or may not be the same parties involved in 30 years. as much as I like to think I'm going to live forever, Father Time is undefeated.
Sure.
And so these are very important decisions.
Yeah. It also is a way advisors or clients often ask me, how do I monetize my land? How do I provide? It's expensive to own land, especially in Texas, and to
Yes.
hold on to that for many, many, many generations. And so it can be a tool for landowners to provide an income stream for their families to be able to keep the property intact by having a power plant on their property, a renewable project on a portion of their property that would be for a 30-year time period, but finances the future of the ranch and what they're able to do with their family. And I was talking with a client recently, maybe it provides some monetary compensation with regard to a succession plan or inheritance
Right.
of, you have one kid who wants to be on the ranch and one kid that doesn't have an interest in coming back, then it allows you to do some estate planning
Right.
that's different. So it's worth, I think, for landowners to have that conversation and just know what their options are so that they can make good decisions about what is it that they really envision for their family and their property.
Right. Absolutely. Could not agree more. And also to your point, every family operates differently, has its own dynamics. Every ownership structure for a piece of property requires a unique, in particular, analysis as to what's proper for this. As we're contemplating a long-term land contract, the long-term implications of these contracts, it's very important to sit down and think about who will be involved at what points in time and what does that look like practically? Does that work? And do we need to put anything in place on the front end as we think about that today, whether that's an entity or trust and all of these things, because there's something that we need to think about. Let's have that conversation here with our firm.
Yeah. And this is ongoing for landowners. I mean, I think when projects were, they first started coming up 20, 30 years ago,
Yeah.
and they were new and unknown. And then here we are at this level, and the landscape and what that looked like 20 or 30 years ago and what that looks like now, especially with data centers and the amount of
Right.
land that is being used there in the conversations. And Texas really doesn't have a regulatory system for those projects. So it really is making sure landowners get counsel, making sure that the local governments are involved and that you're knowledgeable about what the opportunities are, because all of the regulation is really happening at the federal level at this point.
Right.
So.
Right. And through the years, regulations are always evolving.
Yeah.
Right. So you need to stay on top of that. You need to be hyper aware of what that is, but protect yourself on the front end. You have the power to do that yourself contractually and at the local level to have a large degree of control at those levels. And really, it's just, I can't emphasize enough that it's important that you understand what those long-term implications are. And from a practical standpoint, why are these projects developed the way that they are? It's something that is not intuitive to those who haven't been around them. I think because we sometimes we have an oil and gas mentality a little bit to say, because we have witnessed it for 100 years. We haven't been able to witness this for as long. We don't have the regulations in place yet. We'll see. We'll see how that evolves.
Yeah. And I think what landowners should hear too is, with someone with your experience, you can really zoom out at a larger level and go, oh, well, that's where the transmission line is being planned, or that's where it is. And the reason why this site for this renewable project or a data center project is moving forward is because there's resources there to tie into. It makes that project doable or not doable, and really look at it on a bigger scale.
Right. And I mean, doing so just from a practical standpoint, it allows you to know, what is it that's actually being planned and why? And what is the actual viability of this idea on paper? How likely is it to actually reach that finish line? Because well over 50% of these projects that are on paper, that are leased up, they never see construction. It never happens. So that's not the plan for landowners who sign.
Sure.
They're, once we get to that point, if landowners want to proceed, everyone wants the thing to be built. If the operations rent and everything, that's what you're after.
Yeah.
From a financial compensation standpoint, not the smaller upfront option payments. So, but yeah, understanding the landscape and your partner, the viability of the project, engineering, why. I really want to know why. Like, why here? And looking at just some practical aspects of topographical constraints and things of that nature. If a company isn't even aware that X percentage is over here in a floodplain of a project, or you have a bunch of creeks and streams crossing a property that is probably going to create a federal nexus when you lay the collection lines. Have you thought through all these constraints? Because I don't want to option a property. I want my client to option their property for 3 years, and then you all of a sudden start looking at it closely and realize it's not buildable. You just wasted 3 years where the landowner may have had another opportunity for highest and best use for their property. So is a solar farm the highest and best use for this particular property? Let's have that conversation with the landowner if they're thinking about long-term financial planning.
That's such a great point. Well, Nathan, thanks so much for joining me today. I learned a lot from just having this conversation because this is not my practice area. So I appreciate it.
Yeah.
And if you're okay, then let's come back. Let's see what happens with the federal government and the permitting, and we'll come back to this venue and update landowners on what's happening in a few months.
That sounds great.
All right.
Yeah.
Well, that's a wrap for today's episode of Your Texas Land. We hope you enjoyed hearing more from Nathan. And like I said, thanks for joining me today, Nathan. Until next time, keep being an advocate for Texas land, and thanks for listening.
The information in this podcast is provided for general informational purposes only and may not reflect the current law in your jurisdiction. No information contained in this podcast should be construed as legal advice from Braun Gresham PLLC.